In this lecture, we will discuss regarding air piracy or hijacking. So, the very definition and meaning of air piracy or hijacking as given by Elizabeth Martin on the definition and meaning of air piracy or hijacking is seizing an aircraft by use or threat of force. So, hijacking refers to the seizing or exercising control of an aircraft in flight by the use or threat of force. The offense of aircraft hijacking essentially consists of taking or conversion to private use of an aircraft as a means of transportation and forcibly changing its flight plan to a different destination. Theft of the aircraft itself, a robbery of passengers or crew has not normally been the practice of hijackers during the past 2 decades, although both acts have been placed on occasion. So, hijacking is prohibited in international law by the Tokyo Convention 1963, which defines the conditions under which jurisdiction may be assumed over hijackers, but does not oblige states to exercise such jurisdiction and does not create an obligation to extradite hijackers. There is also a convention of 1970 and a Montreal Convention of 1971 creating the offense of unlawfully seizing or exercising control of an aircraft by force or threats and of sabotaging aircraft. These conventions provide for compulsory jurisdiction as well as extradition, as it is being mentioned by Elizabeth Martin in her work in 2003. So, we would like to discuss international law and air piracy as it began with the Aerial Navigation Regulation 1910, then the Convention on Civil Aviation 1944, then Geneva Convention on the High Seas 1958, the Tokyo Convention of 1963, the United Nations General Assembly Resolution of 1970, Hague Convention of 1970, and the Montreal Convention of 1971. So the convention relating to the regulation of aerial navigation 1910 recognizes that every nation has complete and exclusive sovereignty over airspace above its territory, and that each contracting state undertakes in times of peace to acquire freedom of in-ocean passage above its territory to the aircraft of other contracting states. And the Convention on International Civil Aviation in 1944 provides that each contracting states agrees that all scheduled international air services shall have the right, subject to the observance of the terms of the convention, to make flights into or in transit non-stop across its territory and to make stops for non-traffic purposes without the necessity of obtaining prior permission and subject to the right of the state flown over to require landing, and the very Geneva Convention on High Seas 1958. The reference is made to piracy by aircraft through Article 15 of the Geneva Convention on High Seas 1958 defines air piracy to consist of any illegal acts of violence, detention, or any act of depredation committed for private ends by the crew or the passengers of a private ship or aircraft, and directed on the high seas against another ship or aircraft, or against persons or property on board a ship or aircraft. The emphasis here is on the high seas against another ship or aircraft. So the Tokyo Convention 1963 consider an offense and certain other acts committed on board aircraft, which was signed at Tokyo on September 14, 1963 under the auspices of the International Civil Aviation Organization, and which came into force on December 4, 1969, forbids unlawful seizure of civil aircraft in flight and charges the contracting state with the duty of restoring such aircraft and cargo to the rightful owners and facilitating resumption of the interrupted flight as provided under Article 11 of the Tokyo Convention of 1963. Articles 13 and 16, which provides that the main emphasis on restoration of property and resumption of flight, provide that the offender may be taken into custody by any contracting state and held for criminal procedure or for extradition, but neither action is mandatory. The Tokyo Convention made no frontal attack upon the offenses of hijacking. So, the United Nations General Assembly adopted a resolution on November 25, 1970, which condemned all acts of aerial hijacking and called upon states to take all appropriate measures to deter, prevent, or suppress acts within their jurisdiction at any stage of the execution of these actions, and to provide for the prosecution and punishment of those who perpetrate such acts in a manner with the gravity of those crimes. Further, the Hague Convention of 1970, which is the International Conference on Air Law, convened at the Hague, Netherlands, under the auspices of the International Civil Aviation Organization in the year 1970, adopted on December 16, 1970, the Convention for the Suppression of Unlawful Seizures of Aircraft. So, Article 2 of the Convention of 1970 obliged the state party to make the offense punishable by severe penalties, while Article 4 of the Convention enjoined on state parties to take measures to establish jurisdiction over the offense and related acts of violence against passengers of aircraft. Further, Articles 6 and 7 provided for taking custody of a hijacker present in a contracting state's territory and obligations for prosecution of non-extradited alleged hijackers. The convention applies only to civil aircraft and not to aircraft used in military, customs, or police services. So, in order to give effect to the convention, Great Britain passed the Hijacking Act in 1971. Further, regarding Montreal Convention of 1971, it was convened by the International Civil Aviation Organization, and the very convention for the suppression of unlawful acts against the safety of civil aviation. So, Article 1 of the Montreal Convention enumerates the following unlawful acts as offences for the purposes of the convention. For example, act of violence against a person on board an aircraft in flight if that act is likely to endanger the safety of the aircraft, or destroying or causing damage to an aircraft in service so as to render it incapable of flight, placing an aircraft in service, any device or substance which is likely to endanger its safety in flight, the destruction or damage of air navigation facilities or interference with their operation, if any such act is likely to endanger the safety of aircraft in flight and the communication of information which is known to be false, thereby endangering the safety of an aircraft in flight. So the Montreal Convention has broken new ground and goes beyond more codification in providing for international legal action to be taken by states in respect of many acts which, however reprehensible they may be, previously were not considered eligible for treatment in an international convention on criminal matters. So, these are the important conventions which developed the rules in checking and preventing or controlling air piracy or hijacking. Now we would like to discuss certain major hijacking incidents such as the Palestinian guerrillas, then the Entebbe incident of Uganda, then the TWA Flight 847 in 1985, the Indian Airlines Flight 421 in 1984, then the Indian Airlines Flight 423, then IC 814 in the year 1999, then the Air France Flight of 8969. So, in that connection, first we would like to discuss the Palestinian guerrillas. So, the subject of aircraft hijacking assumed great importance in September 1970 when Palestinian guerrillas hijacked as many as 4 planes and destroyed 3 by blowing them up, including a Pan-American jumbo jet which they had hijacked to a desert district in Jordan. So the latest case of hijacking were practiced not for escaping from one country to another, but in furtherance of the war of liberation, as the Marxist extremists and the Hamas among the Palestinian guerrillas stormed it. And the second most important incident of air piracy or hijacking, that is the Entebbe incident, brought into prominence the propriety of the right of a nation whose nationals are victims of air hijacking to save them from the jaws of death, even by the sovereignty of the nations where the terrorists may have skyjacked the plane. So on June 27, 1976, the Air France flight to Tel Aviv lifted off the runway at Athens airport. The hijackers, who styled themselves as members of the Popular Front for the Liberation of Palestine, seized control of the plane, which had 242 passengers and 12 crew members aboard. The hijackers flew to Entebbe airport in Uganda, where hostages were held for 6 days in a dusty, unused passenger terminal. The hijackers' purpose, as proclaimed by them, was to force Israel and 4 other nations to release 53 Palestinians or pro-Palestinian terrorists currently were in jail. So, on June 30 and July 1, 1976, the hijackers released their non-Israel passengers, reducing the number of captives from 253 to 106 on July 4, while there was a smooth screen of negotiations. Airborne Israeli commandos swept into the airport and rescued more than 100 hostages. All the 7 hijackers were killed. Israel lost 4 of its citizens, 3 hostages, and an army officer. 20 Ugandan soldiers were also killed. In July 1976, there was an acrimonious debate in the Security Council. African and Arab nations denounced Israeli action as violation of sovereignty and territorial integrity of Uganda. The Security Council and the Secretary General of the United Nations termed the incident at Entebbe in Uganda a serious violation of the sovereignty by a member of the United Nations. And another major incident that is relating to the TWA flight of 847 in 1985, the Algerian guerrillas of France, then the Indian Airlines Flight 421 in 1984, which was hijacked by the All India Sikh Students Federation. Further, the Khalistani extremist hijackers hijacked the Indian Airlines Flight 423 in the year 1985, and the most important incident of hijacking of an Indian airlines is the IC-814 in 1999, and it was an aircraft belonging to India. So, the hijacking took place in 1999 by the Pakistani hijackers for release of the terrorists as captives kept in Indian jails. So ultimately the government of India negotiated with the hijackers and released those three named terrorist soldiers, Masum, Azhar, and finally the airlines IC 814 was released by the hijackers. And for another important incident of hijacking of the Air France Flight 8969 by the Algerians also an important or major hijacking incident in the history of air piracy or air hijacking. And this is all that we have dealt in the part 1 relating to definition and meaning of air piracy or hijacking, then those international law relating to air piracy and hijacking and how it developed through aerial navigation regulation 1910, the Convention on Civil Aviation 1944, the Geneva Convention on High Seas 1958, the Tokyo Convention of 1963, which strictly prohibited air piracy or hijacking and consider it is an offense. Then the United Nations General Assembly resolution of 1970, the Hague Convention of 1970, and finally the Montreal Convention of 1971. Now we would like to discuss the second important portion in our upcoming lecture that deals with anti-hijacking laws in India as part 2 relating to air piracy or hijacking, which is a part of international law.